Albertans are familiar with the concept of probate. But did you know there are actually 3 different grants or court orders that Alberta courts may issue after someone dies? And knowing which one applies in your situation determines a whole number of very important things. Who has the authority to act? How fast you can move things forward? And what say you'll have in the process. So today I'm going to clean up that difference. My name is Chad Graham. I'm an estate lawyer from Edmonton, Alberta. And this video is to give some general legal advice, but doesn't constitute solicitor-client privilege or specific advice to your situation. Well, let's start with what probate actually means. Probate comes from the Latin probatus, meaning tried, tested, or proved. It's the court process through which the Court of King's Bench in the surrogate matters tries and tests and proves the will, thus validating that will and confirming the executor's legal authority to act. Now, people will use probate as the catch-all for all the things in here, and that's okay, but we need to know a little bit more when we think about the actual way it's going to work. So the grant of probate, that's what you get when there is a valid will. And that will names an executor who is able and willing to act. The court confirms that will is legitimate, confirms you're the person named, and issues you legal authority to administer the estate exactly as the will sets out. The second one is a grant of administration. A grant of administration is what happens when somebody dies without a will. The law calls this dying intestate. And this comes from the Latin prefix in for not and testatus, to make a will. For someone who dies intestate, without a will, there is no document directing who should act or who should inherit. So the court appoints an administrator. Now, it's important to know that Alberta's legislation and the surrogate rules set a defined order of priority for who has the right to apply. It generally starts with the surviving spouse or adult interdependent partner, then it moves to adult children, then to other family members in a very specific order that your lawyer can help you work through. But here's the critical thing. Without a will, an estate isn't distributed according to anyone's personal wishes. It's distributed according to the Alberta Wills and Succession Act's intestacy rules. And these may or may not look like anything the deceased person would have wanted. And it also takes a little bit more time. So you have the grant of probate, you have the grant of administration, and the other one, most people have never heard of unless they've had to apply for them. I've done a number of these. They're called a grant of administration with Will Annexed. So what basically happens here is the grant applies when there's a valid will, but there's either no executor named, yes, that happens, or the named executor has predeceased, died, or is unwilling or unable to act, and there's no alternative named or available. In these cases, someone applies to the court, and the court appoints someone to administer that estate. But unlike true intestacy, that person still has to carry out the will's actual instructions. The will still governs who inherits. It's just a question of who's authorized to act. Here's why this isn't just terminology. The type of grant establishes who's eligible to apply, what evidence the court will need to see, and ultimately whose wishes control the distribution, the deceased's or the province's through the intestacy formula. It's certainly better to know at the outset which one might apply in your case. I've had a number of people who have begun to act and then found out they weren't the right person, and now there was a bit of a mess. But there's a huge caveat here as well. Not every estate needs any of these grants. If everything passes by survivorship or a named beneficiary, you may just administer this informally. Certainly worth having a conversation and figuring that out. But knowing which fork in the trail you're on changes everything about how you will walk the rest of the path. So if you're not sure which of these 3 grants applies to you, or if you can maybe do without any of them, that's the exact kind of question that a short conversation can answer quickly. And if hearing this has made you think, oh, I need to have a will, you absolutely do. Why not get started today at chadgrahamlaw.com. Thank you. I'll see you in the next episode.